Good morning and welcome to our webinar, Mental Capacity Act 2005, 10 Years of Empowering and Protecting. My name is Sheree Green and I lead the Court Protection team here at Anthony Collins Solicitors. We work closely with our colleagues in the health and social care sector, advising specifically on issues related to mental capacity and mental health. This webinar is part of a series of celebratory events marking 10 years since the implementation of the Mental Capacity Act. So what are our aims for this webinar? Well, we need to review. Any anniversary presentation must include an element of looking back to reflect on how far we've come. From your perspective, of course, the focus will necessarily be on the present, and so we'll be looking at how to use the MCA principles and fully embed them into your service. There's room for improvement also, and we will end the webinar by looking ahead to see where certain aspects of the legislation which are not working well or are confusing or too complex may need some revision. So the good old days, before we had to wrestle around the implementation of this key piece of legislation. I'm going to begin by reading you an extract from a short story. It's written by a GP and reflecting on his training experiences in a hospital some 20 years ago. This is shared with permission of the BMA, and the full story can be accessed on the link on the slide. I don't think we should be doing this. Sarah turned to face the group to say, I'm not going to, and I don't think any of us should either. All eyes turned to our teacher, standing by the bedside of Mr. Jones, a ball of curled, breathing bedclothes with a shock of white hair just visible. Mr. Jones here has a rectal tumour, something you must all learn how to recognise if you want to save lives from cancer. He also has advanced dementia, so I will need to hold him in position while you all examine his tumour. Remember what I've taught you. A cancer feels craggy and hard. A benign enlarged prostate will feel smooth. You may see some blood on your glove finger. This is not normal. Remember to use the lubrication jelly. The procedure is not comfortable. Because of his dementia, though, he won't remember any of this. Mr. Jones was not very communicative. The ball of bedclothes moaned. A scrawny arm had disentangled itself and pushed the registrar's hand away. Annoyance came first. How dare Sarah abstain on behalf of us all? Annoyance swiftly yielded to unease. She was, unfortunately, right. Suddenly, I did not want to participate in this learning experience either. Moral distress ripples past me into the rest of the group, but we did not have the words with which to defend our fledgling consciences. I don't think we should be doing it. It's wrong. Don't be silly. You'll have to learn what this feels like if you want to pass your exams and be good doctors. He won't remember. The registrar's voice louder now. I found that my throat was dry. I wanted to come to Sarah's defence, but I also wanted to hide. He's not in any position to give informed consent to an intimate examination, and it's an undignified and uncomfortable procedure. It's not right, and I think it might technically be illegal, said Sarah. At illegal, we were ushered on to another patient, and no more was said. How far we have come. Thankfully now, applying the principles of the Mental Capacity Act to this scenario, we see a gentleman who lacks capacity to consent to an intrusive and unnecessary intervention. There's no evidence it would be in his best interest to proceed, so hopefully now we would see this uncomfortable scenario as a thing of the past. When I started high school, I struggled with maths. My father worked in science and technology, so I asked for help. Some 30 odd years since he'd been in school, he was a bit rusty, but happy to help. But I would despair when he announced that we'd have to go back to first principles to work the problem through. I just wanted the answer. Now, the Mental Capacity Act was the first of a number of pieces of legislation to be underpinned by 5 core principles. And now, no longer a frustrated teenager wanting to get the job done, I hold these principles dear, as I'm sure you do. If in doubt, start with the principles. And here they are, in plain English, courtesy of Skills for Care. The presumption that a person has capacity to make their own decisions. The need to give all practical support to help them make that decision for themselves. The fact that we can't assume that someone lacks capacity because they make a decision which we think is eccentric, wrong, or bad. And when someone can't make their own decision because of lack of capacity, that decision has to be made in their best interest. And when making a decision in someone's best interest, we are looking for the least restrictive option. They're familiar to us, but how do we apply them? We're going to begin by having a look at Martin's situation. This is an example of the principles in action. I am Martin's Property and Financial Affairs Deputy, appointed by the Court of Protection. So Martin is on the move. He needs to leave his flat and move into supported accommodation. And there's therefore a housing association tenancy agreement that needs signing. So a bit of background information about Martin. He sustained a head injury, unfortunately, in an accident some years ago, and he has some compensation which is managed by me. So our question is, how do we apply the principles of the Act in this scenario? Now, it might be tempting for me as deputy to jump in here. There's a legal document that needs signing. But let's have a look, first of all, at my Court of Protection order. So the order contains this particular clause. Sheree Green is appointed as deputy to make decisions on behalf of Martin that he is unable to make for himself in relation to his property and affairs, subject to any conditions or restrictions set out in this order. So I have authority, but we need to note that it's to make decisions that Martin can't make for himself, and it's also subject to any restrictions in the order. And paragraph 2C, this clause always appears in deputyship orders. The deputy must apply the principles set out in section 1 of the Act, that's the MCA, and have regard to the guidance in the Code of Practice. So I'm authorised to make decisions if Martin can't make them for himself, and I must apply the principles of the Act to this scenario. The order goes on to say that the court is conferring general authority on me as deputy to take possession or control of Martin's property and affairs and exercise the same powers of management and investment that he has, subject again to the conditions below. The conditions tell me I cannot purchase any freehold or leasehold property on Martin's behalf without further order of the court, and I can't sell, mortgage or otherwise dispose of freehold or leasehold property in which he has a beneficial interest, again without further authority of the court. Now, Martin has a flat. It's a flat that he owns, and it's a flat to sell. So I see immediately from this order that I've got to go back to court to get a specific further order of the Court of Protection authorising me to sell Martin's flat. But there's no mention here of a restriction on me signing a tenancy agreement. Signing a tenancy is not the same as purchasing a leasehold property. So I have authority to sign the lease, but again, I must start from the principles. Again, remind you, the first principle to start off by thinking that the individual Martin can make his own decision and giving all practical support to enable him to make that decision. And in this instance, what happened is that the housing provider met with Martin, talked through the tenancy agreement with him, was satisfied he had capacity to enter into the agreement, he understood all the information relevant to the decision, all the expectations on him as a tenant, what he could expect from his landlord provider. He could weigh the information, so Martin signed his own tenancy agreement. And just a reminder that capacity is decision specific. Although Martin cannot manage all of his property and financial affairs and therefore has a deputy, he can nevertheless make a decision to sign a tenancy agreement, and you may also be interested to know that Martin has the capacity and has in fact made his own will. Every decision being treated quite differently. Let's just have a look at the impact of the MCA in two particular areas over the last 10 years. Interestingly here, we've got the growth in the number of lasting powers of attorney being made. There are now approximately 2.5 million registered lasting powers of attorney, and around a third of those are health and care lasting powers of attorney rather than property and finance. Obviously, if you're providing services to somebody with impaired capacity, then you're going to be presented with both lasting powers of attorney and to some extent the old enduring powers of attorney, which, if you recall, related only to property and finance. And I'll make some comments about what you may need to be thinking of when you're presented with these documents a little later on in the presentation. Another interesting impact has been the introduction of deprivation of liberty safeguards and the increase in the number of applications that you can see here. A lot of growth since 2014 when we had the Cheshire West case. You can see it looks as though there's a bit of a dip at the moment. That's largely around uncertainty over procedure and lack of resources on the side of local authorities. Anybody who provides services for children or young people in circumstances that may deprive them of their liberty, you'll be interested to know that there is a decision being published today which is meant to have a significant impact on deprivation of liberty arrangements going forward for younger people, an impact that could be as significant as the Cheshire West decision, so you may want to check that out. So just moving on, a reminder of the principles. These are the principles that need to be embedded in our services. The principles which each of our staff member must be basing decisions around and applying on a daily basis. And so we're just going to have a quick look now at how the court has been applying these over the last 10 years. So we're going to have just a quick look at a few cases. In CC and KK, we had unanimous expert evidence that an 82-year-old lady with Parkinson's disease and dementia lacked capacity to make her own decision about leaving the care home and returning to her own home. Interestingly, the judge, Mr. Justice Baker, disagreed with all of them, and he found that she did have capacity to decide to leave the care home and return to her bungalow. He warned that there is a risk that professionals can feel drawn towards an outcome which is more protective of the adult and fail to carry out an assessment of capacity which is actually detached and objective. He described the protection imperative where professionals can attach too much weight to their own views of how best to protect the physical safety of this lady without attaching significant weight also to the lady's view of what would be the right way of meeting her needs, including her emotional needs. And in this case, she'd not been asked the right question in the capacity assessment. She'd not been given full information of all the practical support that could be available to her if she did return to her bungalow. So she'd not had the tools with which to weigh up information, look at the competing options, and make a decision. So that decision focused around her capacity, and the judge went against all professional views on that. In the Ria M case, we've got another elderly lady in a care home who again wants to go home to live in her bungalow with her long-term partner. In this case, everybody agreed that she lacked the capacity to make that decision for herself. And in those circumstances, a decision has to be made as to what is in this lady's best interest. Should she stay in the care home, or should she be supported to go home? It was an application made by the lady with support. She wanted to go home, and the clinical commissioning group responsible for her care opposed it. They were providing services for her considerable medical needs, and particularly the management of her diabetes. The judge considered the factors that needed to be weighed in working out what is in her best interest. That included a strong wish to return home, the best option for managing her diabetes, which was certainly the care home, the risk to her health if she returned home, and he said that having weighed all of these matters up, he reached the conclusion that the case for continuing to deprive her of her liberty was not made out. There certainly were many uncertainties in her returning home, and all kinds of consequences of a negative nature could follow if she did return home. But he went on to say, in the end, if she remains confined in the care home, she's entitled to ask, what for? If the only answer that can be provided is to keep you alive as long as possible, in my view, that is not sufficient. There is little to be said for a solution which attempts, without any guarantee of success, to preserve for this lady a life without meaning or happiness, and which she regards, with some justification, as unsupportable. Much more recently, you may have heard in the news the case of Briggs. This was PC Briggs, a police officer who received a severe brain injury in a road traffic accident and was left in a minimally conscious state. There was a disagreement between his wife, Lindsay Briggs, and the clinical team as to what was in Mr. PC Briggs' best interest going forward. He lacked capacity to make any decisions for himself. And it went to the Court of Protection. There was no advance decision made by PC Briggs and no welfare attorney appointed. In December of last year, Mr. Justice Charles ruled that it was not in his best interest for him to continue to receive clinically assisted nutrition and hydration. And he went on to say, there were important legal, medical and ethical issues here to balance out, and strongly held views. We're looking at the right to self-determination being balanced with the sanctity of life, and then how do you balance sanctity of life with quality of life, and the law is evolving as we speak in this area. And finally, very recently, a case on best interest. Just last month, this judgment was delivered in relation to a veteran, a former soldier, who had sustained a serious brain injury at the hands of another soldier. He wanted to travel to Belgrade to undertake experimental stem cell treatment, which he strongly believed might improve his prospects. The Ministry of Defence opposed this. The official solicitor appointed to represent his interests in the proceedings opposed it. But again, we had Mr. Justice Baker noting the man's strongly held views. Now, when you come to look at best interests, there is no hierarchy of factors in the Mental Capacity Act. We weigh up all of the relevant factors, his views, the views of others, the wider circumstances, the wider implications, and try and sift it down to come out with a conclusion as to what's in the person's best interest. How a person feels about it themselves is just one factor in the sifting process. It's not given particular prominence or significance. But in this case, Mr. Justice Baker gave particular prominence to the gentleman's views and satisfied that he wants the treatment and that he wants it very much. And his strength of feeling was then a key factor in what was described as a finely balanced decision, but it did result in an order approving the plan. So let's look at your services now and how you might go about embedding MCA practice in your own service and in your service delivery. So, a quick reminder of the test of capacity. First of all, just to say that it is decision specific and time specific, as we saw with Martin at the outset. The first question, of course, is whether there's any impairment or disturbance in the functioning of the person's mind or brain. If there isn't, the person makes their own decision. We do not go any further in a capacity assessment. If there is an impairment, however, then we move on to consider the next set of questions. Can the person understand the information relevant to the decision? Can they retain that information long enough to make the decision? Can they use or weigh it in making the decision? And can they communicate their decision? If the answer to any one of the four questions is no, then the person lacks capacity to make their decision. So we're going to have a little look at Leo as a case study, applying the theory, if you like, to the potential realities. And you might want to use Leo as a case study within your own staff training arrangements. You can extrapolate this approach to specific clients and specific situations within your actual service. So, we've got Leo. Leo is going out for the day. He wants to wear his favourite outfit, which is his shorts, his t-shirt and his flip-flops. Bit of background information, it's mid-January, there's a covering of snow. Leo has a learning disability and likes to communicate non-verbally. The trip is a trip to the cinema, and your task is to help Leo to prepare. So we're looking at using the 5 principles of the MCA and the MCA 2-stage approach to discuss how you might approach your task. So, as I said, we start with the principles. We're presuming that Leo has capacity, although his learning disability may put us on notice that he may have some difficulty making a particular decision. We want to support him to make this decision himself, and just because we don't think it's sensible to wear summer clothes in January doesn't mean that Leo necessarily lacks capacity to make the decision. If I do decide he lacks capacity, then we're looking at best interest, and the best interest decision that will be the least restrictive option. So we apply the test. He has a learning disability. It is an impairment or disturbance in the functioning of the brain. Therefore, I consider Leo may have some difficulty. How do I help him? Okay, well, I need to produce the information for Leo in the right format, that it's snowed overnight, he's going out, it's going to be cold, the clothes he wants to wear may not keep him warm, he may feel cold or uncomfortable. He could take a jumper or a coat or some outdoor shoes to wear also. Thinking about the way Leo likes information shared with him, pictures, symbols, being creative but not patronising. He has to take all the relevant information, use it, weigh it up. How may I help? Opening the window, taking him outside to feel the snow, the cold, etc., using his favourite visual aids. If I ultimately assess he has capacity, he makes his own decision. If I assess he lacks capacity, I need to make the best interest decision. I need to factor in his feelings about this. You know, a very restrictive option might be to say, well, Leo, I'm sorry, if you want to wear these clothes, you can't go out. Highly restrictive. Other more creative options on a best interest basis may be to suggest that he wears his clothes, but we have an extra set of clothes to go over the top, or we bring the minibus straight up to the door, etc., so that he's not out in the cold for any unnecessarily long period of time. Let's take Suki now, a different scenario. So Suki is a customer or a service user of yours. She's got dry skin and applies cream each night. Suki's father wants Suki to have an over-the-counter cream he has purchased applied every morning also. Suki's unhappy about this but doesn't want to upset her father. He tells you he's got power of attorney and you are to apply the cream. Suki is 36 and has difficulty with her short-term memory. Again, how might you use the 5 principles of the MCA and the 2-stage test to work this out? And this is very much the sort of scenario that one of your frontline staff may have to be dealing with. So again, this can be used in staff training. We look at the 5 principles. We assume Suki has capacity, although memory problems may indicate that she may have difficulty making a particular decision. We want to support her to make this decision for herself. Although her father has strong views, if she's got capacity, she can make the decision for herself, even if he has power of attorney, and we need to check that power of attorney. If she doesn't have capacity, then it's a best interest decision, potentially. We then need to check whether the decision is in the scope of her father's power of attorney, and again we're looking for the least restrictive option as a best interest decision. So again, you know, she's got short-term memory issues, and this could be a symptom of an impairment of the mind or disturbance, which leads us into the mental capacity second test. Let's get the information for Suki at the right time when she's perhaps most receptive. What is the relevant information? Well, she needs to understand the dry skin, that her doctor has given her cream, that her father also wants her to have this extra cream. Father's cream may or may not help her skin, other specific implications that applying the cream may have on her. She only needs to retain the information long enough to make the decision. Doesn't matter that Suki may later forget, and she needs to use and weigh it. And it's okay to include pleasing her father, or wanting to please her father, within the decision-making process, as long as all the other factors are in there. If she has capacity, she makes the decision herself. If we assess her as lacking capacity, we need to have a look at this power of attorney, and does the attorney have authority to make this decision on Suki's behalf. The validity and the scope of any power of attorney needs to be checked and a copy kept in the person's records. If it's an attorney under an enduring power of attorney or property and finance power of attorney, he has no authority to make this decision for her. If it's a health and wealth lasting power of attorney, he may have authority to make the decision, but we need to check the document carefully. And this will be one of those decisions where we may want to or need to refer our assessment on to explore the legal implications around the power of attorney, or the medical implications around the interference with the prescribed cream with the GP, and or the potential of a dispute with Suki's father. So an awful lot to think about in that scenario. So let's look at who assesses capacity in your service. So there are a whole range of decisions to be made each day. Some are made by frontline staff in the moment. Others need to be referred on or up. So here are some very day-to-day examples, which your frontline staff may be there having to assess capacity within or making a best interest decision. I put down there PCSP, which I suppose stands for Person-Centred Support Plan. It's the care plan. So there may be a note within the person's care plan of the sorts of decisions that the person does have capacity to make and who your service is happy assessing capacity around and making best interest decisions around for these particular scenarios. They can get more complicated, of course. What money do I have access to? How I spend it? What information of mine is shared with others? Those may be decisions where the management have a role in assessing capacity and best interest decision making, and again recorded in the care plan. Medical, dental treatment. In all of these circumstances, it is the clinician proposing the treatment who should be assessing capacity and then making a best interest decision, and again recorded in the person-centred care plan. More significant life decisions: where I live, who shall I live with? You know, these are issues where if there is nobody formally authorised to make an order under the Court of Protection or a lasting power of attorney, then best interest decision making will need to be undertaken with involvement of families and the relevant authorities, and again all documented in the care plan. Most significant decisions, these are the sorts of decisions where if there is a dispute, there's such high impact decisions that authorities, care providers often want to see the court to make a decision, such as the cases we've had a look at earlier, and again all copy documents will be held in the person-centred care plan. So for your service, obviously the whole range of levels of involvement in assessing capacity and best interest, always being mindful of when references should be referred on or upwards. And for your service, okay, you know, your service has its own particular set of needs. Identify the applicable decisions, decide who's authorised to assess capacity in each domain, incorporating all of these sort of elements into your own policies and for new staff, your induction, and then into your ongoing training. People claiming authority, we mentioned this with Suki. We have all kinds of people next of kin, appointees, attorneys and deputies, people with a Court of Protection order. Next of kin has no legal meaning or legal authority until somebody is dead. At that point, they do have a legal next of kin. It has no meaning for somebody who is alive and needs decisions making for them. Appointees are people appointed by the Department of Work and Pension to manage state benefits, state retirement pension only. They have no authority whatsoever to make decisions or to manage other income or capital assets or savings, and absolutely no authority in relation to health and welfare. Attorneys or deputies, important steps is to check the document, the scope of the authority. As we said, even if a person has an attorney or a deputy, if the person has capacity, they should be making their own decisions with appropriate support, and the attorney or deputy only stepping in if they lack capacity. So in these circumstances, even if we've got a power of attorney or deputy order or Court of Protection order in the records, it means that staff still need to be assessing capacity on the ground. We need to retain a copy of the authority within the person-centred care plan, within the care plan, and as we've said, even where there is such authority, we still consider assessing capacity ourselves. So again, embedding the MCA into your organisation, my recommendation is that all staff know the 5 principles, they apply them, they understand how to test capacity, and they apply it all day, every day, in all of those little decisions. That as a service, we think about your customers, your clients, the sorts of decisions they need to make, that we assess capacity capacity that we record and that we share through training, through induction, information about our clients, our service users' decision-making capacity. Thinking about your staff, when and how they should assess capacity, and embedding training, both as an induction and then refresher, and perhaps case studying as we've looked at with Leo and with Suki through regular one-to-ones. Thinking about your policies, applying them, having template forms for assessments, capacity for best interest decision making, and use them. Make sure they're there within the care plan. And finally, thinking about your culture, different ways in which you can embed the MCA. Largely, I would suggest, by talking about it, by sharing stories about your particular client, day by day. Is your service effective? This is one of the 5 questions asked by the independent regulator of health and social care in England, the CQC. Is your service effective? What does effective mean? It means that the care, treatment and support you deliver achieves good outcomes for your service users and helps you to maintain their quality of life and is based on the best possible and best available evidence. That is what an effective service is. What does effective look like? So I've got an extract from a CQC report where a service achieved good in this particular domain. A number of things were said, I'll list them all, but we will just have a look at the first couple, which are most relevant to us. So an effective service is where the principles of the Mental Capacity Act 2005 were being followed. Capacity assessments were carried out and lasting powers of attorney were checked. Staff had been trained sufficiently to support people effectively. So that's what I'm going to suggest is there for you in how you aim for or sustain good and work towards outstanding as a service in the effective domain for the CQC. How do you demonstrate that on the ground? Well, do you remember Leo going out in mid-January in his flip-flops and shorts? So we can imagine a conversation with a roaming Care Quality Commission inspector wandering about your service and chatting away to Leo's carer, support worker, PA. How might that go? Tell me about Leo, they might ask. And they could continue, well, Leo's been with us about 3 years. He's 25, lovely sociable young man, gets on really well with our other customers. He's got a moderate learning disability and he's on the autistic spectrum. Sometimes he has seizures, and on a bad day, it can be tricky for him to make his own decisions. He likes to communicate with his picture cards. That might be what they say in response to that. Can Leo make decisions for himself? How is your staff member going to respond? Well, I always assume Leo, like all our customers, has capacity to make his own decisions. I know this is an important principle of the Mental Capacity Act. But he has got a learning disability, so does find some decisions difficult. I always try and help him. I do this mostly by using his picture cards. Sometimes he has difficulty concentrating, particularly after a seizure. So if the decision's not urgent, I wait a while till he's feeling up to it. Explain to me how you help Leo to make his own decisions, etc., etc., etc. What do you do if you think Leo might not be able to make a particular decision? We offer bespoke training for health and social care providers, and this conversation is taken from an exercise within that training, whereby we explore how that conversation may go. And it's a sort of conversation that the frontline staff should be able to have confidently with a CQC inspector, because they know their customers, they know their service users, and it's simply perhaps some practice at how to think about explaining their role to a CQC inspector as we aim for that good or outstanding grading when the report comes out. If you're interested at all in our training, we offer a fixed fee training package, and we will come and deliver our training with your service. It can be handled as either a whole service training, or we can train the management or the senior staff who can then take it back and roll out the training with frontline staff and all members of your team. I mentioned that we would end with some room for improvement, and the next 10 years, and what might that look like? I suppose the simple answer is that until every service is achieving outstanding for its effectiveness, then yes, we all have room for improvement. Just to give you an indication of the extent of the work to be done, however, in the last few days there's been a report issued by the East Sussex Safeguarding Board, and it's a review they've carried out regarding a gentleman who had Korsakoff syndrome, who's a former alcoholic, and he died in July of last year in a nursing home after refusing care and treatment with many health conditions. He aggressively refused to accept treatment for some leg wounds. The leg wounds became foul-smelling and infested with maggots in the final days of his life, such as these maggots dropped from his leg as he walked around the care home. Now, the capacity assessments about his ability to decide for himself on care and treatment were mixed. There was one capacity assessment which said he had fluctuating capacity to decide for himself whether to reject this treatment. Another capacity assessment in hospital said that he did have capacity to choose to refuse treatment, although he lacked capacity to decide where he lived. The nursing home staff obviously were crying out for help. He was under a deprivation of liberty safeguard, which had lapsed. A request had been made for an advocate, and no advocate could be provided due to lack of resources. He was referred to a consultant psychiatrist who said that he couldn't be sectioned under the Mental Health Act to be forced to have treatment for a physical issue, and therefore he was not detained under the Mental Health Act either. Of course, he could have been possibly detained because treatment for his mental health issues may have resolved his unwillingness to receive the treatment for his physical health problems, and in fact his leg wounds. The difficulty was that his case fell between the two stools of mental capacity and mental health, and that is one particular area where there is a massive need for improvement because it is so complex that the professionals are unsure how to deliver care in these circumstances. Sadly, in this case, the man simply fell to the ground and died. But one of the areas for review will be how mental capacity interfaces with mental health, particularly when we have people declining treatment for these sorts of issues. There have been other criticisms, of course, of the MPA. You may recall the House of Lords Committee being seriously critical of the supplementary provisions to the Mental Capacity Act that were introduced by the Mental Health Act 2007, introducing deprivation of liberty safeguards. They were described as poorly drafted, overly complex, bearing no resemblance at all to the ethos of the Mental Capacity Act. Following on from that, we had a Law Commission report and a new bill published in March of this year, to which the government issued a brief interim response only yesterday. The outcome really is that the only way forward with dolls is to start again. We also have the UN Convention on the Rights of Persons with Disability reporting recently and criticising the UK for overuse of substituted decision making, where we step in and make a best interest decision rather than supported decision making for impaired capacity, where we help people to make their own decisions. They in fact have recommended that the Mental Capacity Act is torn up and we start again. That is highly unlikely to happen. And of course we've had announced very recently the new chair for a set of consultations around mental health reform, with the intention of working towards parity of esteem with mental health care and physical health care. And again, as we've seen from the recent case from the local authority, East Sussex, a lot of work to be done over the interrelation between those two areas. Recommendations made by the Law Commission included a new scheme to remove deprivation of liberty safeguard system called Liberty Protection Safeguards. They've also, though, interestingly, recommending mechanisms to improve decision making generally across the Mental Capacity Act. And one of the issues is to change the weighting on the various factors in best interest decision making. As we said before, what the person feels and thinks themselves about an issue is just one factor to take into account. The recommendations are that particular weight is given to the wishes and feelings expressed by the individual who is at the centre of that decision making. Other issues, well, they're recommending far greater access to advocacy, and wouldn't that be wonderful? They're looking at a provision whereby people can consent in advance to being deprived of their liberty, which is an interesting and somewhat controversial notion. They are doing away with emergency deprivation of liberty. All deprivation of liberties under liberty safeguards needs to be planned. Unlawful deprivation of liberty will contain a right to damages if the liberty protection safeguards are not implemented appropriately, and they've also made some recommendations around changes to the Coroner's and Justice Act 2009. Just to tell you a tiny bit about liberty protection safeguards before we finish, it will be a new scheme applying across England and Wales, and it authorises specific care arrangements. So the care plan has to be worked out in advance. If it's genuinely urgent, there isn't a mechanism for moving somebody on an urgent basis, but it has to be genuinely urgent. The intention being is that the authorities will be doing a lot more work up front and not simply finding a placement, moving the person, and then everybody having to look at deprivation of liberty as an issue. It will apply to 16s and over, whereas the current framework only applies to 18s and over, and it will apply to all settings, whereas deprivation of liberty safeguards only applies to care homes and hospitals, and you need a court order currently for all other settings. And the responsibility will be shared between the NHS and the local authority, which hopefully is a little bit of good news for the local authority. As I mentioned, there are damages for unauthorised deprivation of liberty, so all care providers will need to be sure that, obviously once the scheme is up and running in its final form, that arrangements are in place before a person begins to receive services. And finally, what will all this mean for the future? Well, hopefully, when best interests are considered, we will see much more consideration and weight given to the person's wishes and feelings. I think this in turn might see a shift away from risk aversion and conservative practice and paternalism. Often the professionals are accused of believing they know what is best for the person. We've got the new liberty protection safeguards, which may see light of day at some point. The interim statement issued yesterday said very little about a time frame for any real change or progress. And we may see a move to try and placate the United Nations Convention on the Rights of Persons with Disability towards less use of best interest and much greater efforts made towards supporting the person to make their own decisions. So that brings us nicely to the end of our seminar, our webinar. I'll just have a look at the questions. So there's a few questions here. Let's have a look. The first question is, will copies of the slides be made available? Yes, you can certainly request copies of the slides, but that's an easy question for me to answer. Let's have a look at the task we've got. So somebody's asking here, is it really necessary to obtain copies of powers of attorney? Well, yes, I have to say it is. I mean, we've seen that in the CQC report. I mean, somebody claiming to be attorney is potentially taking on significant decision-making role for the person. It's important that's documented, and as we've seen, it's important to check the scope of their power to make sure that what they're proposing to do is actually within the scope of their authority. Otherwise, when the CQC come along and ask us, you know, where is our evidence? Look. Next question is, we mentioned damages for unlawful deprivation of liberty. How, you know, can you protect yourself as a provider against that scenario? Well, it's a little bit outside the scope of today, but there are defences available to a provider. If you reasonably believe the arrangements don't give rise to deprivation of liberty, or you reasonably believe there is an authorised deprivation of liberty, then you're not liable, and you're also not liable if you've made the appropriate referral to the responsible body. But that's the draft bill as it stands. And in that case, you'll be covered as long as it takes the responsible body to deal with the referral. If at all times, though, you continue to believe on a reasonable basis the person lacks capacity to consent, and the arrangements are necessary to prevent serious harm, serious deterioration in their treatment. And the final question I've got here, in Suki's case, would there not be a fresh decision to be made each morning as to whether she is happy for the Queen to her father to be applied that day? And I would wholeheartedly answer yes to that. You know, every day capacity fluctuates. I think it's only the right duty to ask Suki on every occasion. And I think sometimes in those circumstances, the capacity assessment, the best interest assessment is something that, you know, the staff member will simply take on and embed, and it will become second nature. So yes, absolutely. On each occasion, the right thing to do is to ask Suki afresh and to make that decision afresh. Doesn't mean it has to be necessarily documented each day, but it should certainly be assessed each day. And I think that brings me to the end of all of the questions. Thank you very much for joining me. Oh, sorry, a last question. Can we also request a copy of the recording, please? Yes, the recording is available afterwards. It's been recorded and it is available to download and share with staff or with colleagues. So I hope you all have an enjoyable rest of the day. It's been my pleasure to share these thoughts with you, and thank you for joining us to Help us in our 10-year anniversary celebrations. Goodbye.